see who is appearing. Very good. All right. All right, gentlemen, you were on the 11 o'clock, and I see here, okay, Mr. Jacobs as well. Let's see. There we go. And you were on the 11 o'clock session, so you probably, some of you may have heard me indicate that each of you, as you know, given 20 minutes to make the argument. And if you're the appellant, to please, you could ask up to 5 minutes for rebuttal. But let me ask Mr. Jacobs and Mr. Grimsley, have you all decided how you wish to divide your time here, if any?
Yes, Your Honor. We will split our time evenly 10 minutes with myself going first, followed by Mr. Jacobs.
Oh, very good. All right, gentlemen, then that would be great. So with that, I'm going to ask you both to mute your microphone so we could get to hear from the appellant's attorney. Whenever you're ready, sir, the court is ready, Mr.
Good morning, Madam Justice. May it please the court. I would ask for a reservation of 5 minutes of rebuttal time.
Very good, sir. Thank you.
Thank you. I am here representing ITG Naples Real Estate LLC, which I will refer to throughout as ITG. ITG was a non-party purchaser at a foreclosure sale. It was a stranger to the foreclosure action at the time of the foreclosure sale. We are seeking the reversal of the trial court's order as amended, which granted plaintiff's motion to vacate the sale and certificate of title, which was filed on June 12th of 2020. The basis for that is we contend that the trial court applied the wrong law, or in the alternative, misapplied the existing law. And the confusion there is because the order is not really clear as far as what was applied. We contend that the law regarding vacating a judicial sale arises out of the law of restitution. That is for an erroneous judgment, not a void judgment, but an erroneous judgment that's reversed on appeal. And that dates back to the 1800s and comes all the way up through a third DCA decision in 1988. To the extent that the court sub silencio was seeking to apply the statute 702036, we contend that that statute pertains only to 540B motions. And as I'll go through probably under questioning, the only cases that have ever construed that statute are all arising out of 540B motions. So to apply that body of law to the issue of restitution to a non-party after a judicial sale is a misapplication of law.
Also, I ask you to address an issue right up front for me. The timing of the foreclosure sale and the timing of the appeal. It appears there's approximately a month. So there's an appeal that was filed, then the foreclosure sale. So there's some public notice of that, as well as some lis pendens that were pending. Could you kind of address why that should not affect your client's ability to proceed in this matter?
Yes, Mr. Justice Stargell. The sale, the judgment of foreclosure was entered on the 16th of January, 2016. The appeal was filed 6 days later, and the sale took place on February 18th. And we have conceded in our statement of facts, and we do not contest that my client at the time of the sale had both actual and constructive notice of the pending appeal. However, when we go into more depth on the Sims case specifically on page 886 states that a stranger to the record is unaffected, that does not disqualify one to be a bona fide purchaser just because they had notice. It's expressly stated by Sims in the Sims case on page 886. If they are not in privity with a party, then they are entitled to the bona fide third-party stranger protections in equity from restitution. Because as you know, restitution, a fundamental tenet of restitution is it can only be obtained from the party that wronged you. It cannot be obtained from a third party. I'll just flesh out the facts then, since Your Honor mentioned the facts. The certificate of title was issued on the 29th of July, and possession was taken at that time. A month later, the funds that were paid, which were $1,405,000, were dispersed to Bank of America. That was in 2016. This honorable court reversed the trial court, stating that the trial court should have allowed Mr. Sorensen to amend his pleadings before trial to assert claims of fraudulent documents presented by the bank allegedly and perjured testimony presented by the bank to establish standing. I would note that at no time in this case was there any contention that the mortgage was paid or satisfied or anything of the sort. These were merely, for lack of a better term, process crimes, let's call them. The mandate was issued in February of 2019, and it wasn't only until approximately a year later that Bank of America moved to vacate the certificate of sale and the certificate of title. That was 4 years after the sale, 3.5 years after the funds had been dispersed to Bank of America, that was filed. And then that motion was eventually granted, though, and an order was entered in May of 2020. So that's the timeline, Your Honor. So addressing the law of judicial sales, it arose, as my brief states, out of Garvin v. Watkins. That, contrary again to the assertions in the order, which stated that none of these cases arose, in mortgage foreclosures. In fact, all the cases arose. Most of them arose directly in mortgage foreclosures reversed on appeal, as in Sunday. The remainder arose either, they were all judicial sales. It could have been a judicial sale of real property that arose after executing a money judgment against the real property. But again, I contend that shouldn't make a difference. A judicial sale is a judicial sale. It has certain rules. So in Garvin v. Watkins, there was an action to enforce a lien that resulted in the sale of the property to Watkins. Garvin brought suit to recover the property, but he was a non-party, the purchaser, so the court refused to vacate. But it did agree to change the amount of damages in the erroneous judgment. But the sale entitled to the property remained with the non-party purchaser.
Mr. Bunner, is it, you pronounce your name, is it Bunner or Bunner?
Bunner, Your Honor.
Mr. Bunner, help me out. And maybe this is too simplistic on my part, but in this case, I guess you are the third-party purchaser. You took the title contingent on the final judgment foreclosure being affirmed on appeal. And in this case, it was not. So you were on notice of that appeal. And how do you rebut the appellee's argument that you're not entitled to the protection of being a bona fide purchaser under this?
Madam Chief Justice, I would take issue with your very first statement of law. I believe that Sims, which led to Johnson v. McKinnon, which led to the, I will call them the Heron v. Sundry trilogy, and as recently affirmed in the case of American Bankers versus Williams, states that regardless of whether you were on notice of an appeal, if you are a third-party purchaser, stranger to the action, unless the judgment is void, the sale is not vacated. And although both parties have said that I'm using anachronistic old law, it is not old law. As recently as 1981, the third district issued the opinion of American Bankers versus Williams. And I beseech you to not make up your mind until you have looked at that case. It is crucial. It is a new case, and it construes Heron v. Sundry properly, both the third district's prior decision, it is a third district case, and what the Supreme Court said about it. What keeps appearing in cases after the third district's decision in Sunday is this phrase: it is apparent that a sale pursuant to a judgment which has been reversed is not a valid sale. Even the third district in American Bankers versus Williams unequivocally states that is not the law. The law is not that all sales are vacated when the appeal is reversed for any reason. And we can go through that, I'm prepared to go through that in depth right now if you'd like to. In American Bankers, there was a sale of a property pursuant to a judgment which had been reversed on appeal. And American Bankers cited directly to the third district decision of Heron v. Sunday and said a sale of property pursuant to a judgment which has been reversed on appeal is not a valid sale as to the parties to that appeal, which is correct. And the earlier statement by the third district could be construed much more broadly to apply to anything. But they said it was only the parties to the appeal. They then go down and cite directly to the Supreme Court's later decision in 1971, which in some cases is referred to as dictum. It says a party against whom an erroneous judgment has been made is entitled upon reversal to have his property restored to him by his adversary. A party to the case. a party to the action. And if you look at American Bankers, it goes further to prove my point. The bank, American Bankers, bought the property at the sale there. Now, American Bankers then said, we've since sold the property to this person, Vega. So you shouldn't apply that rule and allow the sale to be reversed because Vega is a third-party stranger. You'll note that the court, the third district didn't say, no, that's ridiculous. Anytime the judgment's reversed for any reason, the sale gets vacated. It said, American Bankers is not entitled to invoke Vega's rights as a third-party purchaser. So again, implicit in that is that Vega did have rights as a third-party purchaser, but they would not allow American Bankers to assert the defense of the third party to prevent the unwinding of the sale. Therefore, the third district said, regardless, if a party is the first purchaser, if the party is a purchaser at the foreclosure sale, the law of restitution will continue to apply even if they've alienated the property thereafter. There's no question in this case that the party, Bank of America, well, I'm sorry, there's no question in this case that the party, Bank of America, did not buy it, that a third party bought it. So our rights to continue to hold title apply. The only way—
Mr. Butner, can I ask you something? And
Yes.
maybe I'm being overly simplistic.
Yes.
I have a problem with the bona fide purchaser status, but apart from that, I mean, the key to this issue is your client apparently has not been able to get its money back from the bank. So my question is, would you remind me what, if anything, is in the record about efforts at getting the money back from the bank?
Well,
that's what the case is
let me
about, it
address both
strikes
things.
me.
The money, from our perspective, not getting the money back from the bank is not the issue here. I think that fleshes itself out. So that's really not, it's not in the appeal. We're not claiming that you should allow us to keep title because we haven't gotten our money back. It's what happened was when the court entered its original order, I believe that the trial court was unaware that money had been paid out some 3.5 years earlier. So it ordered the clerk to disperse the money back to my client, the buyer. I think she thought they were a lot closer to the sale. And then when she became aware, because the clerk advised her, and we had actually advised her as well orally, that the money had been paid out long ago, she then subsequently amended her order, without hearing or anything, to take that language out. And we've kind of been at a standstill since then. So, I mean, to us, where the money is not really, it's not germane to the issue of do we get to keep title under the law of restitution. As far as the bona fide purchaser aspect of it, I would say Sims and the other cases seem to set forth that under the law of restitution, under that body of law, you, regardless of whether you have knowledge of the pendency of the appeal, you are bona fide and if you're a stranger to the action, you are a bona fide purchaser and it does not preclude you. Now, it creates a scenario where a client like mine buying at a foreclosure sale basically has to chew his nails for a long time waiting for an appellate court to issue a ruling. Because if that ruling is that judgment was void, that judgment was either rendered without jurisdiction or whether somehow a party was denied due process of law, making the judgment void, then that would be a different story. But where it's simply an erroneous judgment, that does not change, that does not put the third party purchaser's title to the property in peril under these clear cases. So stepping back to American Bankers, as I said, it did not allow American Bankers who bought at the sale to invoke the shield that was available to Vega, which obviously, if I'm wrong, if my impression of this case is wrong, Vega had no shield to be invoked by American Bankers. And if any reversal resulted in the vacation of the certificate of title, all of that is nonsense. The entire decision makes no sense because they're talking about nothing. Does the court need a recitation of Sunday or is the court familiar with Sunday well enough? I'm sure
I don't think you need to go through those, Mr. Bunner. No need to do that.
Right. Okay. Needless to say, the Supreme Court's position was that a third-party purchaser is not the same as a party to the action. A third-party purchaser will not have its title vacated under the Supreme Court's statement as adopted and applied in American Bankers. There was an issue of, again, I mentioned that body of law in 702-036. That body of law is not applicable. You can see that it's not applicable just on the face of the statute. This court, even in comparison to its peers, is very good about statutory interpretation and not going beyond the bounds of statutory interpretation. If one looks at the statute, section 1A, for example, it says where a party seeks to set aside, invalidate, or challenge the validity of a final judgment. That's one scenario. That's not here. That's a 540B motion. Here, they are not. They're attacking a certificate of title, and they're attacking a sale, an order of sale that were ancillary to the judgment. So it's not that. So that would only leave the second half of the statement, which is, or if they're seeking to establish a lien or encumbrance on the property in abrogation of the final judgment. I think it's a stretch of the words to say that that's what a motion to vacate the sale is, but even if it were, it's not in abrogation of the final judgment. Again, you use the plain language of the statute. Abrogate, to abrogate means to annul or cancel.
Mr. Benner, you're actually going into your rebuttal time right now.
Okay, I don't wish to, so please, I'll allow them to go.
All right, very good. Thank you, sir. All right. So, Mr. Grimsley, if I'm going to trouble you, Mr. Benner, to please mute your microphone.
I'm sorry.
Oh, no problem, sir. And Mr. Grimsley, whenever you're ready, sir, please proceed.
Thank you, Your Honor. May it please the court. Will Grimsley on behalf of Applee Bank of New York Mellon. I just wanted to start by addressing Judge LaRose's concern about the money in the funds, and we agree with Mr. Bunner that it's not an issue in the appeal. Your Honor asked for where in the record you might see something about that. I would just direct Your Honor's attentions to Appellee's appendix. That would be our Bank of New York appendix, pages 149 and 170, where that issue is discussed. And it is abundantly clear that the return of the funds is not an issue in this appeal. Bank of New York does not contend that if the sale is undone, that the funds would not have to be returned. That's just something that would have to be addressed down the road. Addressing the primary issue, the case law upon which ITG relies, it dates back to 1892, the early 1900s, and even into the 1970s. The problem, though, is that the legislature in 2013 enacted 702-036, which is entitled The Finality of Mortgage Foreclosure Judgments. The statute itself does not expressly limit the application of that statute to Rule 1540B motions. Certainly, it contains language that indicate that challenging or seeking to set aside a judgment would probably fall under a Rule 1540B motion, but challenging the validity of the judgment is exactly what Mr. Sorensen did in this case, the defendant below. He challenged the final judgment on a direct appeal of that judgment, and it was ultimately reversed. So the statute still applies here. The big difference, and I'll say to kind of clarify the difference between what Mr. Bunner is relying upon from the common law and the statute itself, is the protections afforded to a non-party purchaser in a foreclosure sale. The case law that he relies upon certainly stands for the proposition that a non-party purchaser is entitled to keep the property if the judgment or decree of sale, as they used in the old cases, was reversed on non-jurisdictional grounds. That's still provided for in 702-036. What the legislature did, and what is expressly clear, the intention demonstrated in the statute, is they just further limited the situation in which a non-party purchaser would be entitled to keep property following the reversal of a final judgment on appeal. So when a party seeks to challenge the validity of a judgment, which Mr. Sorensen did here, the court cannot grant relief that would adversely affect title in that non-party purchaser if, and that's the big if, there are 4 preconditions that are met. The first precondition, the party seeking relief from the final judgment was properly served in the case. That is consistent with the case law dating back to the early 1900s. If there is improper service, the judgment is void, and therefore the non-party purchaser would not be entitled to keep its property. However, the additional 2 through 4 subsections there are additional preconditions that have to be met for title to the property to not be adversely affected. And I'll drop down to number 4, which defines that the purchaser has to be a bona fide purchaser, not affiliated with either the plaintiff or the defendant. Number 2, and that's not disputed here. Number 2 is that a final judgment was entered. That's not disputed here. Number 3, and that is where the intention of the legislature is expressed, that all appeal periods have run as to the final judgment, with no appeals having been taken or all appeals having been resolved. So that's where I have not heard an argument on the other side of how you get around number 3 there. What you have here is a third party, non-party purchaser who almost a month after the final judgment was appealed, made the decision to buy the property. And at that point, it was dependent upon the outcome of the appeal. And unfortunately, the appeal was reversed. And with that, the proceedings below were to continue. And part of that process was necessarily to undo the foreclosure sale. There's a couple cases I'll draw the court's attention to, one of which, and they're all cited in our brief, one of which is the Palacio case. It's a decision from this court in 2010. And this decision also predates the enactment of section 702-036. But in that case, this court looked at and considered the Sunday decisions, both from the Florida Supreme Court and from the 3rd DCA. This court recognized that what the Florida Supreme Court said in Sunday was dictum, and it did not apply here. It was not controlling here, I should say. But what the court expressly said is that the 3rd district's decision, the intermediate decision in Sunday, is more persuasive in that, and I'm quoting directly from this court's decision in Palacio, it is apparent that a sale pursuant to a judgment which has been reversed is not a valid sale. And this court even emphasized that in the opinion. The next case that I would draw the court's attention to is the 90 Seawolf case out of the 3rd DCA. And this too was cited in our brief, 245 Southern 3rd 925. And this case is really on point here. One of the arguments made by ITG was that that on appeal here is an order granting a motion to vacate a certificate of title following a prior vacation of the final judgment. And so if you look at 90 Seawolf, that's exactly what was going on. In 90 Seawolf, the plaintiff, I should say, moved to vacate the certificate of title after the court had previously vacated the final judgment. The vacation of the final judgment was not an issue on the appeal. And all that was at issue on the appeal, and this is at head notes 1, 2, and 3 at 927 of the opinion, was whether the court grossly abused its discretion in vacating the certificate of title and sale following the prior reversal of the final judgment. And what's interesting is the non-party third-party purchaser in that case invoked 702-036 and argued that it was entitled to the protections afforded under 702-036 because the final judgment was reversed, or because it fell as a bona fide purchaser. What the 3rd district did in that case was analyze 702-036, looked at the facts of the case, determined that the defendant who moved to vacate the final judgment was not properly served, which was a failure to meet the first precondition of 702-036 under 1A. The court did not elaborate and go on and evaluate whether the second through fourth preconditions were met because it didn't need to. But comparing that to this case, there is no dispute that Mr. Sorensen was properly served in the case. The precondition that fails is the one that the property be purchased after or be purchased without pending appeals. And that's what precondition here was not satisfied. So 90 Seawald is one of the few, if only, cases that does an analysis of 702-036. And it is apparent that that's applicable in this situation, whether the court should or should not vacate a certificate of title. And the fact that ITG does not satisfy that third precondition under 702-036 1A means it is not entitled to the protections afforded under the statute. Now, looking specifically at what Judge Brody did in this case, she has
if I may, Mr. Grimsley, I know you indicated 10 minutes. You have 30 seconds left on that 10 minutes, but I know Mr. Jacobs has asked for 10 minutes as well. So I just want to alert you to that.
I'll wrap up in 20 seconds. Thank you, Your Honor. So just in paragraph 6 of the court's order that's on appeal, the court says that ITG took title to the property with notice of the appeal, and the court relied on Heron Palacios and 90 Seawald. And by referring to 90 Seawald, clearly the court considered the 702-036 analysis that the third district did in that case. So for these reasons, we would ask the court to affirm the order granting our motion to vacate certificate of title.
Very good. Thank you, sir. All right. Mr. Jacobs, you've got your 10 minutes, sir.
Thank you, Your Honor. So first off, may it please the court, I just want to take a moment and note, this is the first time ever in probably 10 years of litigation in this case that I have to say, I agree with everything Bank of New York Mellon's counsel has said. It is all true. And let's be clear, like what's happening here. There are players involved in this. And Mr. Grimsley represents the banks. I represent the borrowers. Mr. Bunner represents the third-party purchasers. And I think that what Judge Kuzam and what Judge Stargell both pointed out was there's notice here. Clearly, there's list penances. We filed our own list pendants just to make sure that there'd be absolute, actual, and constructive notice. And Mr. Bunner doesn't just deny that they have actual and constructive notice. And there's also no question that Mr. Bunner is going to get his money back. And I think that it is something that for him to even argue that there should be that somehow he's out of his money is not really fair, because he could get it if he wanted to. And there's, I think a very unique situation that we're dealing with here. Mr. Bunner would like for this court to radically change the law. And it's the law that this court in Palacios said in 2010, 11 years ago. It's the law that the third DCA said in 90 Seawald, that when you have an appeal and the foreclosure judgment gets reversed, the property goes back to the borrower. Even under 1.540B, it would be inequitable to have it continue forward to give the judgment prospective application, because the borrower's property was taken from them. And the law that Mr. Bunner would like for you to do is to say, well, anytime that you get served with a foreclosure and there's a judgment entered improperly and it's reversed, Mr. Bunner's third-party purchasers get to keep the property. And he makes this argument up of them biting their nails about they're so worried. And I just want to kind of lay that issue bare. This is a calculated decision for a windfall. In this case, the judgment was close to $2 million. And Mr. Bunner's client put up 1.4 million. And he wasn't biting his nails. He was placing a very good bet that he was going to get the property for 60 cents on the dollar. Why? Because it was on appeal. That was a benefit to him. He said, I knew that it was on appeal. And that's why they went for it. Because if in fact the court had not found that there was a violation of due process, there wouldn't have been any, he would have just had the property at a nice discount. And the biting the nails is kind of dissuaded from the fact that in this case, Mr. Bunner's client took control of the property without a writ of possession, just tossed my guy's stuff out into a locker and kept the property until he was, until he lost title, until the judge and the trial judge ruled that they don't have title anymore. And he had use of the property the whole time, and he gets his money back. So there is no prejudice whatsoever to Mr. Bunner or the third party purchasers here. And the question becomes, are we going to change the law to now create this dynamic where anytime a borrower is sued in foreclosure and served properly, even if they win on appeal, they lose their property to Mr. Bunner's clients? And that's not what the legislature says. The legislature says, no, if you win on appeal, a direct appeal, you get your property back. It's not what this court said in Palacios. That's not what the third DCA said. So all of this comes down to this fundamental premise of, do we go back to these cases from the 1800s that Mr. Bunner, and I'll give him credit, he's an excellent lawyer. He's been able to come up with all kinds of great arguments. He had a $67,000 sanction award imposed against me, and my client got paid $30,000 by my client and hasn't returned that money, and is still here asking for the property, knowing that the court's ruling in the appeal was that the borrower was not given the opportunity to be heard about his defense, that the property, that the evidence in support of the foreclosure was fraudulent. And I submit that the ultimate law that we all follow is the Constitution. And the Fifth Amendment clearly says no person shall be deprived of life, liberty, or property without due process of law. And I heard Mr. Bunner in his argument acknowledge that there was no due process. If there's no due process, that's different. But I don't think that you can really, I think you need a bright line rule. And the bright line rule that we've had all the way, through this whole, since 2010 from this court is that if the foreclosure gets reversed, the property goes back to the homeowner, because everyone's on notice. And today, when you're going to buy a property, you certainly have access to go online and look at the court file and see what's there. And you can see if there's a notice of appeal. You can see if there's a list pendants. And these guys are certainly doing that because that's why they're betting. That's why they're throwing in this low bid number with the hope that they're going to have a windfall. And when they get through the whole process, what all they really care about is making a dollar. And that's great, that's fine, but we're here for something bigger than that. And if my client can lose his home, even after the Judge Guzam writes a unanimous opinion saying he was denied the right to speak, he was not given an opportunity to be heard, that's a violation of due process. That is probably what will happen in a lot of cases going forward, as we're about to go into COVID and a whole new wave of foreclosures are coming. I'm sure there's going to be due process arguments. And I don't think the court should be accepting Mr. Bunner's invitation to look at, well, what happened in this particular argument? What was the issues raised on appeal? Was it this? Was it that? No. It's a simple rule that we have in place today. Everyone's on notice about it. That's why Mr. Bunner's client bet, a price that was hundreds and almost $500,000 less than what the judgment was. And he got it. And he got use of the property for the time that he was on appeal. And now he's here saying, well, restitution is about coming from the party. That's not what we're dealing with. There's no restitution coming from the party in foreclosures. Restitution comes from the property. And the property and title, the Constitution says you cannot deprive a person of their property without due process of law. And Mr. Bunner's argument would allow that, as long as you got them served. And that's not what the legislature says. That's not what this court said in Palacios. That's not what was said in the in 90 Seawalt. And I just think that that he's on notice. They did this intentionally. He shouldn't get a windfall, and he's going to get his money back whenever he asks for it. The bank's willing to give it back. They have it sitting there waiting for him. And unless the court has any other questions, I would ask that you affirm, and I would even ask that you write an opinion that makes it clear that when a borrower comes in, a third-party purchaser knows that there's an appeal pending, and knows that there's a statute that says that is going to be controlling, and knows that there's a chance that they're going to buy this property, they'll get their money back sure that you can make sure that's clear too, that they should get their money back when it's appealed, but that it could otherwise result in a violation of a party's due process rights under the Constitution, because you've got to expect that there's going to be appeals that get reversed. I mean, isn't that always what we're saying when an appeal is reversed, that you didn't get due process, you didn't get the process that was due, which would have allowed them to say that it was a valid judgment. If you got due process, you should be affirmed. If you didn't get due process, you shouldn't get affirmed. And for those reasons, Your Honor, I would ask that you, make sure that we clarify the law in this area, and make sure that Mr. Bunner's clients know exactly what risks they have and what benefits they're going to get when, it does, in the rare instances, it doesn't go in their favor. And I yield my time to Mr. Grimsley.
Very good. Thank you. Thank you, Mr. Jacobs. All right, Mr. Bunner, if you have your rebuttal time right now. And Mr. Jacobs, I'm going to trouble you to please mute. Excellent. All right, Mr. Bunner, you have your rebuttal time. Please proceed.
Thank you, Your Honor. Respectfully, although I heard both counsel keep telling you what the law is, they did not cite to a single example of why that's the law. In fact, they both essentially conceded that this law of restitution that I've set forth in the briefs and in oral argument was the law. That was the law. They're saying that I'm trying to change the law. I'm not trying to change the law. That was and is the law. And not back in 1800. In 1988, the third district clarified the Sunday trilogy in its decision. And it's directly on point to the situation. And it says that a third party will not lose the title to the property. Only a party does. I'd like to just speak to Palacios very quickly. Palacios, as you know,
before you leave that other issue, though, what about the argument that the statute came in 2013? Can you just address that, please?
I can, yes. The plain language of the statute, Your Honor, as I read before and explained, it does not encompass the motions that were filed. The plain language of it does not. And the law is crystal clear. I've briefed it out. The Supreme Court has made clear for decades that a statute will not displace the applicable common law rule any further than is necessary. I cited Carlisle versus Game and Freshwater Fish for that. It says a statute, therefore, designed to change the common law rule must speak in clear, unequivocal terms, for the presumption is that no change in the common law is intended unless the statute is explicit in this regard. It is not explicit in this regard. It does not repudiate any of that law of restitution from which the issue here arises. It arises out of restitution, not out of statutes, not out of rules. It arises out of restitution. Thornburg went on and said that's where the Supreme Court applied this rule to determine that a statutory remedy would be cumulative. So it says if it can be cumulative, then you apply both. A later decision that I cited states that the only time the common law is displaced is it is completely repugnant to the statute. So the statute has to be crystal clear, the common law has to be completely repugnant, or the common law persists. And it said in Thornburg, particularly if the remedy is long established. So the fact that I'm going back to 1800 all the way to 1988 with consistent remedies in this circumstance, it bolsters my argument. It doesn't defeat it. It bolsters it. So it says that the language is unequivocal and clear. The legislative intent must be derived from the words themselves. And you don't involve incidental rules of construction. You don't engage in speculation as to what judges might think the legislature intended or should have intended. That's this very court's words in DMV Investment Trust versus Almirada. It also said that it's not the role of this court, this very court's words are, it's not the role of this court to write a better statute. And that was State Farm Mutual versus Smith. So I would contend to you that there is nothing in that statute that displaces the common law. You can't even infer it. Palacios was decided under 45031. It was decided under the rules regarding an appellate, the procedure for a judicial sale. It was unfair. Palacios bid $60,000 because that was the judgment. And then not on appeal, the trial court itself modified the judgment and said, no, the judgment's only $16,000. That put Palacio as a third-party purchaser in a position where he paid, probably $40,000 more than he ever would have bid. It was unfair. That was his argument. That's totally different than what we're talking about here. We're not talking about restitution between parties. We're talking about a third-party bidder who was beguiled into bidding more than he really should have and then prevented the remedy of vacating the sale. It was a third-party purchaser that tried to vacate in Palacios. Not applicable at all. 90 Sewell is a 1540B motion case, and it was decided on the fact that there was improper service. The judgment was void. And so there was never even a need of a reference to Sunday v. Heron because it was a totally inapplicable body of law at that point. If the judgment was void for service, the judgment was void.
And Mr. Bunner, you're
Yes.
actually 2 seconds left on your rebuttal. If you'd like to wrap it up very quickly.
Yes, Your Honor. So we would contend, again, on the bona fide purchaser issue, I just want to read this part from Sims. It says on page 866, Charles Wright, the purchaser at the master's sale under the decree subsequently reversed, was a stranger to the record in the cause in which such decree was rendered. And he, for aught that is shown to the contrary in the record before the court, was a bona fide purchaser of the property sold under said decree. And there is nothing in case law or statutes. In fact, the 702-306 has not been applied outside of a 1540B motion at all. This court most recently addressed it in 2020 in McDonald.
All right,
So
Mr.
your
Bunner,
case of first impression.
All right, I think you've heard the little buzzard. Your rebuttal time has expired. Thank you
Your Honor.
all for your arguments, and we very much appreciate it. All right,
Thank you, Your Honor. Have a great day.
You do the same. Thank you, gentlemen. All right, so let's go through the next case on the docket. The case